Welcome, everyone, and thanks for joining us today for our webinar, Photography, Contracts, and Copyrights, What You Need to Know. I'm Jacqueline Tobin, Editor-in-Chief of Rangefinder, and we're so happy to have you with us today as we kick off our new Business Reset series of webinars with our conference brand WPPI. Now, before I introduce you to our guest speaker today, there's just a few helpful instructions I need to outline to ensure a smooth process. So let's get started. Listening to this webcast. The audio portion of the webcast is broadcast over the internet. So make sure your computer or device's audio is available, unmuted, and the volume is turned up to an acceptable level. If you're having trouble with receiving the audio, please select the question mark in the upper corner of the webinar interface and select Test My System Now. This will give you information on your connection and how to remedy any problems you may have. Often it's just simply a matter of disconnecting and then rejoining the event to allow you to catch a better stream of audio if you're experiencing problems. How to ask a question. I'm sure you'll have plenty of questions at the end, and it's easy to submit them. On the left side of your screen, there's a box labeled Ask a Question where you can enter them. Questions related to the webcast topic will be held and answered during the Q&A session at the end of the event. Questions related to technical issues can also be entered in this box, and they will be answered immediately by our webcast producer. So let's get started. Today we have with us Aaron Arce-Stark. Hopefully I didn't butcher that yet, Aaron. He is an attorney. He represents photographers and other artists and entrepreneurs. He's a frequent contributor to Rangefinder, spends a lot of time breaking down and analyzing cases in the news for us. So I'll stop talking and I'll let Aaron introduce himself as well in terms of, let's just talk about copyright to begin with. I think, Aaron, a lot's happened this year, especially in copyright and contracts. So breaking it down is your job. So I hand it over to you.
Thanks, Jacqueline. Thanks for putting this together. I really appreciate it. It's good to bring this information to everyone. I'm an attorney based in DC. I've been practicing for the last 7 years, and like Jacqueline said, I represent a lot of photographers, along with a lot of other creators as well, and different small business owners. So today we're going to talk about copyright. It seems to be always in the news. There's a lot of things going on. Actually, a new small claims court copyright body has been created. So that's an exciting piece of news that we're going to touch on too. But kind of just starting from the basics, what is copyright? So it's a term that's used a lot. Photographers, obviously know it, but really it is a federal law, and it is a law that provides protections to people who create intellectual property, and intellectual property being with photographers' photos. Something that's come up recently is who really owns the copyright. And this issue was brought to light in a recent news story with a Black Lives Matter protest, and a person had taken a photo of the McCloskeys, the people who were holding guns and pointing them at protesters as they walked by their house in St. Louis. And a main issue of that case, they were sued for copyright infringement by the photographer because they had used one of the images that this photographer had taken of them in a Christmas card. They'd used one of the images, and so the photographer claimed that was an infringement on their rights. So the central issue, though, of that case was, well, who owns the copyright to that image? Generally, copyright is automatically attached to automatically goes to the person who has taken the photo, who presses the shutter button. But in certain circumstances, that's not always the case. They claimed in that McCloskey case that the photographer shouldn't have copyright protection over those images, and that the copyright should be transferred to them, because they claim that the photographer took the photo on their property, so it invaded their privacy. And that raised a couple interesting questions. So when a person takes a photo of someone, perhaps illegally, or maybe through trespass, or invades the right of privacy of someone else, does copyright still go to the photographer? And as a general matter, it does, because that's a separate law. Really, we're talking about copyright law, and then they have this law of trespass. And here, in that case, the two kind of intersected. But copyright allows someone the exclusive right, the copyright owner, to distribute photos, to disseminate them, to make copies of them, and they were trying to say that the photographer shouldn't have those rights. But when you do something, when you take a photo that you may have taken illegally or against the rights of someone else, you're not relinquishing your copyrights, but you may be limited on how you can actually use that image. So in a sense, although you're not giving up your rights, you may be limited on how you can use it. So in that case, that's kind of what the court may decide, and if they may argue in the alternative that the copyrights may not transfer over, but the photographer may be prohibited from using that image in certain circumstances.
I mean, I know we're writing about that right now, and we first did the news story of it. Now you were kind enough to do an analysis for us. That's coming out later this week on rangefinderonline.com. But just to backtrack for a minute, I'm sure there are people out there like myself who might have thought, for me, it was maybe years and years ago, but who might have thought that if you just take your photograph that you've taken and put a copyright symbol on it and put it online or wherever it goes, that doesn't protect you because you still need to register it. Is that correct? So, I think a lot of people don't realize that.
Right. When you have copyright protection, we all, every copyright owner has these certain rights that protects their images, that allows them to prevent others, or gives them the right to prevent others from using their images without permission. But in order to exercise those rights, you actually you can exercise them on your own, but to legally exercise them. So in other words, to go to court and enjoin someone, to stop someone from using the image and to demand damages for their use of the image, you do need to register your copyright of that image with the United States Copyright Office. So the United States Copyright Office is a regulatory body organized by the federal government, and that is where you go and you can apply, put in your copyright application or registration online. You pay a fee, and they analyze it, and they have to accept the registration. And as long as you can show that, as long as you say that you are the owner and, you follow the application process, you're likely to get the registration. But then at that point, once it's registered, which can take some time, sometimes several months, just because it's a bureaucratic system, then, you have the right to go and enforce that in the court of law and demand that. So a lot of times when you find someone that is using your image and you didn't register your photos, you can still send them a cease and desist letter. You can still demand certain licensing fees or damages. But the other side, once they get that letter, likely they're going to ask if you can provide the copyright registration. And if they have their own attorneys, they're going to know that if it's not registered with the Copyright Office, you really can't go to court until it is registered. So you're kind of, you really don't have the enforcement at that point to really act. So it's to act on that threat, that, your letter. So it is important to register it. And just by putting copyright registration symbol or copyright registration or a watermark on images is good. But it's not the same thing as registering those images. It's really good because, one, you are broadcasting to the public, hey, these are my photos. So if someone takes them and they remove that copyright information, that in and of itself is a violation of the law. it's not copyright infringement. It's a violation of the Digital Millennium Copyright Act. It's removal of copyright information, and that is its own separate law that you can sue under outside of copyright infringement. So that's one thing. It gives you another way of enforcing your rights. So maybe you didn't have it registered, but if they removed your registration, then you have a way to kind of still go after, go after someone and some leverage there if they remove that. And also it's evidence too. If that information is removed by the alleged infringer, that removal of that information can be used as evidence of what's called willful infringement, where someone had taken your photo. They can't claim at that point that this was innocent, that they didn't know that it was for someone else. Maybe they say, oh, it was something in the public domain, or, I thought everybody could use it. But when you have your copyright information on there, your name or whatever that signifies that this photo is yours and it's removed, that argument then goes away and you can use that against them. So it is really important to put that on your images, if you can, mark them with your business name, your personal name. So,
I mean, a lot of this, it's very informative and helpful, right? And I mean, for me personally, not this, but in general, it makes my head spin thinking of all these things. Are there the first 3 to 5 steps you would tell a photographer is, register copyright, right? I mean, is it, are there specific steps to take?
Yes. Practically speaking, it is, I've obviously talked to a lot of photographers, and I know it is kind of a pain. It is to register photos with the Copyright Office, but it is something that does give you a lot of leverage and power and negotiation and whatnot. If someone does take your photo, it also, especially if you license your images and they're going to different people, people want to know that the people you're licensing the image to like to know that this is a registered image, that you are the actual owner of this image, and having a copyright registration provides that validation. You can do multiple registrations at once. You can do a bundle. The Copyright Office is going through some changes in terms of the rules and policies, so I don't remember exactly. It used to be you could register up to 750 images in one application for published photos, and it was unlimited for unpublished. And I believe now there's a cap on that. So I'd like to tell photographers that when they're done with their project, like they photograph a wedding, they've culled the images, they've edited them, they've put them off to their clients, take those images, and when they go to your client, you should also send them to the Copyright Office and register them together
right away.
Right away. I think it's a $55 registration fee. You do it once, you get used to it. It's kind of just a matter of practice. It's not too terribly difficult, and that way and it's all done. That's one way to do it. Or the other way is you could register it after this infringement happens. But real quickly, the reason why you might want to register your images first, before they go out into the public, before there's an opportunity for them to be infringed, for someone to take them without permission, is that when you pre-register like that, when you do it early, you do get more rights. You get more. If you did go to court and you win, you get your attorney's fees paid for. That's a big thing. But you have to have your images registered before the infringement happened. So you get your attorney's fees covered by the other side. You also get what's called statutory damages. This is the statute, the copyright law, has a scaled set of money that you are allowed to get. Not no questions asked, but there is a minimum that you will get if you can go to court and prove your case and win. That's really helpful, because if you don't register your images early and you do it, let's say after the infringement takes place, and you decide you want to sue and you win, you actually have to prove what's called actual damage. You have to show the court that this is what you lost on account of whoever used it without permission. And a lot of photographers don't license one image. A lot of them just do, weddings, and they charge a flat fee or something. They don't know what one image may be worth, and so maybe their damages aren't actually that high. You can also look at profits and of whether someone profited off of it, but that may be difficult to show. That's what the issue. The LeBron James case actually.
I was going to bring that up. Yeah,
it has that issue. Is that basically this case that came out? A photographer took a photo of LeBron James. Then he put that on his social media.
LeBron did, yeah.
LeBron did,
right.
And didn't have permission, supposedly, from the photographer or from whoever the photographer licensed the image to. And then the photographer sued, is my understanding, for copyright infringement. And so the defense is that this was fair use. And that one of the issues was damages, that LeBron didn't make any money off of this photo. So if the photographer asks to get compensated by the profits that he made, it's zero. That's what he claims. But then, the other side of this is that anything that goes on to a professional basketball player's, social media page or any celebrity, there's a lot of value in those photos. Maybe it's hard to find the exact right dollar amount, but there is some profit being made by advertising oneself, especially when you're a celebrity. So that's one of the issues that came up. But there's also this other issue of fair use that we can get into if you want to. But it's
because that's mostly pertaining to either news photos or other celebrity, right? Like celebrities or a news photo that everybody's using that same photo. They're putting that, like, if a magazine, if 5 media outlets see a news story and put an image up, right, that's circulating everywhere, and they put up the photo credit,
right,
but it's considered fair use because it's out there.
Right. It kind of depends how it's being used. So there's two sides to copyright claim, right? So you have the person who owns the copyright, and then if there's an infringement, you have the person who's being accused of using the photo without permission. A lot of times a defense that is raised on their side is called fair use. And that's basically just kind of, generally speaking, it's where someone can use an image that's owned by someone else, and can use it without having to seek prior permission for the use of that image, so long as they use it for certain purposes. So a court will look at 4 different factors to determine whether or not that fair use actually does apply. One of them is the nature of the use, or the purpose, how the picture is being used. So if it's criticism, newsworthiness, commentary, or the courts will look at that and say, okay, if it's used for that purpose, then they're not really infringing on the copyright owner's rights. They're actually using this in what's called a transformative way. They're bringing they're using the image in a way that brings something new to it. So you're talking about the news, and something about that image itself, commenting on the image itself. You're adding more to this intellectual property, which makes it transformative, and then someone's allowed to use it in that way and not have to pay damages or to a certain thing. But the point of that too is that it's a defense, so people can raise it before, but generally you're sued and you have to bring that up as a defense. But that's what LeBron's attorneys are claiming.
I mean, it's a defense that might not always work, but it's a defense nonetheless. And then
Yeah. So
if the photographer has like his or her images licensed with an agency like Getty, for instance, is there still a fair use component? Because I feel like if I went in and used a Getty image on a news story, I would have to pay for that.
So, right. And that brings up, so that kind of goes back to the beginning of, who really owns images. And a lot of times when you do license your images to a photo licensing firm like Getty that's going to sub-license out these images. Sometimes you're giving this company, not necessarily Getty, but whoever you're licensing the images to, who are then sub-licensed, sometimes you're giving them exclusive use. So when you give someone exclusive use to use that image, that they can use it in any way they want, you're kind of putting no restrictions on that. And then also you're not yourself licensing out that image, you're just giving it to them to use. You are also transferring, in a sense, you're not transferring copyright ownership, but you are, depending on the contract, you're generally likely giving them the right to sue infringers as well. So they themselves could go after someone who has used that image without permission, and they could then, so like, let's say it was lifted off of this, for example, the Getty website or something like that. Getty might have the authority to, it's called standing, to sue, the alleged infringer at that point. So that is one way to go about it. And you want to just know, when you are taking these images and licensing them out, what rights you are giving away to people, and what limitations at that point. It's something, every license you have should have some agreement. If you're licensing to somebody like that, like a news outlet or something, they're going to likely have their own agreements, but you want to make sure that you aren't transferring this over, your copyrights over. And that's something that can be addressed too. Also, is important to have in your wedding photography contracts too, when you're taking these photos, because although copyright attaches to the person who takes the picture, sometimes that doesn't always work out that way. There's also certain situations like a work for hire, which is kind of a carve out of the copyright law, which allows, which even though the person taking the image is, should be the copyright holder, there's certain things where that work automatically transfers over to someone else. So if there's an employee-employer type relationship, copyright transfers to the employer on that point.
Like if I'm shooting for the New York Times, right, and I'm an employee under that umbrella organization, right, and then I'm shooting for them, and you'll often see like photo by Jacqueline Tobin for the New York Times, because they own.
Sometimes,
they own it,
right. So it depends. So if they're an employee, yes, likely.
Versus a freelancer.
If you're a freelance or independent contractor, generally independent contractors still retain the rights to the image, and then they work out some sort of license with that. That's why it's really important to, with photographers, wedding photographers who photograph with a second photographer, like a backup person, that would be likely an independent contractor relationship that they would have with that person, unless they're an employee of the studio. But if there is an independent contractor relationship, it's important to know that that independent contractor, that second photographer, owns the rights to the images that they take. And so there should be, within their agreement that they have, some sort of clause about, okay, that maybe the images will transfer over, the copyright transfers over to the main photographer, and then maybe a license is granted back to the independent contractor to that they can use it on their social media or whatever, or so specifics around that. Because I've had cases where relationships have gone south between two photographers that used to photograph together. And then the question becomes, okay, well then who owns the images? And the independent contractor goes after the main one and says, you can't use my images anymore. And so it can get really muddy. It's important to really delineate the rights of those images at the onset.
And that's where the contracts come in, and we will get into contracts. And we are flinging a lot of information, but very useful and helpful information. And there will be like downloadable resources at the end. And people will be able to ask questions. But I just wanted to also bring up quickly, like royalty-free images, because you touched on this a little bit, I think, earlier, in terms of, I know social media is a whole other can of worms, but like people who have images online, or, there was a case where a woman had an image, I think, on Unsplash, I think it was. I might be butchering the name of the agency, but basically, she gave away all rights and didn't really realize it, I don't think. And when you join, like, there are stock agencies, but then there's royalty free. Like, can you just touch a little bit on that? And then there are sites where you give away everything and they can just do whatever they want with it.
Right. Definitely read the agreements that you have with these stock agencies, these stock photo agencies, because a lot of times they will want to have you transfer over everything, all the copyright to them. Even if your copyright isn't registered, you're going to still transfer ownership over, and then they can go and register the images themselves. It's more advantageous that they have all the rights to it, so they can do whatever they want in perpetuity and don't have to worry about anybody else claiming royalties for the use of the image. So it is important. You want to look at those agreements. But one thing that when you have these grievances like this, there is going to be this new, which is neat, this new regulatory body, this new kind of way to resolve copyright cases, and other than the courts. So it came out. I mean, it was passed with the last stimulus bill, and it's really neat. It's kind of going to create this small claims court for copyright cases, which I think is going to be good for photographers, because a lot of these times the damage amount isn't all that much, and so it may not be worth it for them to go to court over. And you have to bring, by the way, copyright infringement cases in federal court. It's expensive. You need an attorney. You might have to sue in different in a jurisdiction or in a court that you don't live next to. You might have to go where the defendant is, and you might not have the ability to do that. But with this new small claims court, it's not enacted yet. I mean, it's the money's there.
But it's called the CASE Act, right? That was signed into law, right, at the end of December, I think. But this, like, it was factored into this big omnibus bill, right? Like, there was a portion of that. And so, I think it is a huge victory in a way for photographers. But then I guess it's also limiting the amounts that they would end up getting on the infringement.
But I mean, it's limited to 30,000, which is still quite a bit. So I don't know yet, because it's not been all put together yet. I think they have a year or something like that to put this agency together. And it'll provide a way for them. And I think, you could sue in one central place. Who knows how they're going to have, maybe you can do these things, submit these claims online, and maybe it could be done. I don't know if it's going to be done virtually or what, but it's going to have kind of a central location, I believe, and it's going to be disposed of that way through this new court. It's a little different in that the defendant, though, has the right to opt out. And so they might say, I want to go to federal court. And then they themselves, I believe, can remove the case to federal court. So you may end up in federal court anyway. So it's not forced, but they at least, but that may not be the case. It really kind of depends on the facts of whether it's going to be worth it to them. And they may do that to put pressure on the plaintiff and make it harder for them. That might be a strategy that we might see being used. Is that okay? They're going to file here and remove it, but we'll see. But it's going to be there, and it should be interesting to see how it all unfolds, actually. So it will help, I think, at least maybe not even filing claims, but having that as a potential remedy for photographers to use as a way in their cease and desist letters to say, okay, we can bring this to this small claim court. And maybe it might spark settlement too, because right away the defendant or the alleged infringer is going to know already what the possible damages are going to be. And they might, because a lot of times it's who knows what the amount's going to be. And they might be like, okay, let's start talking if we know you're not going to sue us for more than X amount of money. But it's important to remember, you still have to get in there, you still have to register your photos. So you still need to register your images even to bring it to that new court.
That's a nice way of bringing us full circle on the copyright for now, because I mean, we could talk about copyright for like days. But we are, like, Rainfinders, continuing to cover that, the small acts, the Case Act, which passed or signed into law recently. But maybe we should just talk a little bit now about contracts as well, especially, you know, in this year of COVID, people had to sort of scramble at, you know, inserting clauses into their contracts and things with safety protocols. If you want to just like talk a little bit about like the basics of the contract and how you've seen people like rejigger them this year, or
this has been a crazy year for contracts. I've been reviewing contracts since I started my practice. I've never had to deal with any actual litigation until this year with contract specific cases. There's been threats and there's been letters and back and forth and settlements and things like that, but no actual cases were filed prior to this year. And I got a handful of clients with full blown litigation cases, filed cases against them. Photographers filed against their clients or former clients had filed cases against them. So it's important to know when you have these contracts with your clients as a step one, who is your client. And as funny as that sounds, it's something that comes up over and over again, because what happens a lot is maybe just one of the married couple, engaged couple signs the contract and not the other one. So that's a problem. That may be a problem. And people get at, should both sign. And really the people who should sign the agreement, it should be both. And it should be both, because those are the people you are providing the services to both of them. And so whoever you're providing the services to and giving the products to or whatever, those are the people that are your clients. It's not always the person who pays. So that question comes up a lot, that, the father of the bride paid the bill. Does he need to sign the contract too? The answer to that is no, they don't. And they shouldn't really, because you don't want to make someone a party to the contract that you're not giving the services for, because if you do, then they're going to have rights against you as well. You'll have things against them, but they'll be a party to this whole agreement, and they don't really necessarily need to be. But what you need to make sure is that when identifying who the client is and then who the payor is, you need to make sure that your contract stipulates that whoever is paying may not be your client. So you could put this sort of under, payment section or fee section at the top, and whoever is paying may not be your client, but the ultimate person responsible for paying for this service is your clients. So what has happened, especially in COVID, is that either the contract was canceled or they claimed something else to get out of the contract. And the photographer said, okay, well, this retainer, this initial payment is non-refundable. So we're keeping that. The client says, okay, all right, that's fine. But then what happens is that the person who paid did a credit card charge back. So they came after and they wanted their money back. So then you kind of create this whole mess if they did this credit card charge back, and then the photographer goes after the client and says, hey, your mom did this credit card charge back. You guys got to pay me. And they say, sorry, that wasn't in the contract. We don't have to pay you. And so you got to.
I mean, it gets very, yeah. It goes on and on. But actually, we do have some questions coming in already. Somebody asked, are there, Heather Dye asked, are there things that absolutely need to be included in a basic photography session contract? Because again, it's one of those things that can go on forever too, but What are like the basics that should definitely be in there?
So who the parties are, what services you're going to provide, when you're going to provide them, where you're going to provide them, sort of the basic scope of work. And then what really also needs to be in there is then what you're going to provide. So any sort of issues around the service itself. Are you giving, how many photos are you giving them? Is there an actual number or none at all? Giving them raw files, not. And then you want to have some kind of limit of liability in there as well. So who's the client, payment, scope of work, what you're delivering, and limit of liability, meaning that if something goes wrong, if you are unable to make it, what are you on the hook for? If your clients are unable to show up for whatever reason, what can you keep? What do you have to return? If your camera equipment breaks, or if you lose some of the images, what happens? So those types of things you want to have in there. And you can make it general, for the most, you don't have to list out every single, what I'm trying to say is you don't have to list out every single possibility of things that could go wrong. So you can make it general enough for that, but you definitely want to hit on the fact that if you can't show up, what happens? If your client doesn't show up, what happens then? And if something happens to your equipment, yeah.
And because we are getting a lot of questions, are you okay with me getting into that portion, or are there still basic things you think?
Fire away.
Okay, because it's good that there's a lot of questions, and they're sort of bouncing around some of the topics we've talked about already. So there's not really a basic order to them. But somebody asked, Bob Zan asked, can you explain the necessity for model releases in book publishing by self or otherwise, and are there any exceptions?
So this is so model releases. Most photography contracts are going to have that because you're taking pictures of people. The reason why you have a model type release or a model release is to ensure your use of the images as well. Because like that McCloskey case, even though you might own the copyright to these images, you own these pictures, you may be limited on what you can do with them. So perhaps everybody has a right to control how their likeness is used. So that's why it would be wrong for me to be in an advertisement if I didn't give permission to be in an advertisement and they're used. So when you do these model releases, what you're doing is you're asking your clients to allow you to use these images in the way you want to. So it may be for self-promotion, promoting your own website, promoting your own photography services. So you want to let them know, hey, I'm going to use these photos that show you on my portfolio and maybe on my Facebook or wherever to promote my services. And you're getting their permission to do that. So the tricky thing is, though, is that a lot of photographers want to use images, wedding photographers want to use images of everybody they've taken photos of at a wedding. And going back to the beginning, who's your clients? Your clients are the ones signing away the model release for themselves. They don't have the right to sign away those rights of their guests. So it is important to just to keep that in the back of your mind, that just because your clients give you permission to use pictures of them for promoting that, you may not have permission to use photos of the guest in that way. You can write an indemnification clause in your agreement, which basically shifts the burden. So it means that you can say, the client is giving me the rights to use pictures for self-promotion or advertising, and I'm also going to use pictures of guests. And if a guest files a suit against me, my client will step in and defend me against that lawsuit. That is something you need to, though, explain clearly to that your client needs to explain. You need to explain to your client that there's this indemnification in there. That's one way to kind of deal with that. The other way is to get permission too. You take a picture of someone, you say, hey, do you mind if I use this photo? And you can get verbal permission that works. So, but it's just something to be mindful of. Just because you own the rights to something doesn't necessarily mean you can do whatever you want with the picture. So anyway, that's a great question. So I hope I answered it.
I'm sure it'll pop up. If you did, it'll tell me, they'll ask it again. But I thought it did. And so again, some of these questions now are like relating to things you talked about earlier. So Sandra Krieger asks, so do I have to pay to register my 20,000 photos to protect them? Does every single one, let's say, that she's ever taken have to be registered to get that protection?
No, you don't. You don't have to register them. You are the copyright owner. You always have the right to explain to someone else who's used your image without permission. Just tell them that they've used the photo without permission. If they continue using it, that's evidence of willful infringement. And you can, if you do end up suing, you can use that their continued use as evidence against them. So there's a difference between having the right and enforcing the right. And so to legally enforce the right, though, you can try to enforce it. When I say legally, I mean you're going to the court to do it. You can legally enforce it. You do need to register that image. You don't have the right. The court will not allow you to get into it to file a lawsuit. It will be kicked out unless you have a registration. It's subject matter jurisdiction. You don't have the right to bring it to court if you don't have a copyright registration. So it's hard to legally enforce it by filing a lawsuit. You are always welcome to try and do that without going to court and just letting people know. And a lot of times things are completely taken care of that way. Most of the time photographers don't have their photos registered and they're able to get them taken down. You can also file a lot of the service providers, internet service providers, like people like there's called ISPs, but yeah, so like Facebook or Twitter, Instagram, they have ways that you can report infringement directly to them through a takedown notice. That's called a takedown notice. You could just Google, someone's using my Instagram photo or my photo on Instagram. They have ways to go around to allow you to get it taken down. So you may not get money or anything like that.
But have it.
You can take it down. Yeah. And they have to take it down.
I think you touched upon this earlier, but so someone asked, can you register after the infringement and then go to court to enforce it?
You can.
As long as you do before you go to court, right?
Right.
You can.
To put in the court, you need to register it. But what happens is if you register it after the infringement, you have limited, there's certain damages and costs that aren't covered by the other side that would be covered by the other side if you had registered before the infringement. So like if you win, you get your attorney's fees paid for by the other side. You can file you have that's available to you. I mean, within reason, you have to write a motion. I mean, but whatever, you have the availability to have your attorney's fees paid for if your copyright was registered or your photo was registered before the infringement. The law rewards people who do things proactively, put it that way. Doesn't mean you limit all your rights, but you get more bang for your buck if you do it early.
And Holly Cade brings up a good point. Is everything we're talking about just applicable to the U.S.?
Yeah. So,
right.
So yes and no. I mean, this is U.S. copyright law that I'm referring to. So, but most countries all have a form of copyright law that. I've had cases in Australia. I've had cases in Canada. Some of them are easier. Some of them you don't need to register your photos in order to get to go to court. So they all have different ways, but you can enforce rights in other countries if you find it. It's harder because you're in another country. So if you don't live in that country and things like that. But a lot of times, though, if it's a company, they might have an office in the United States as well, and so you can go at them that way, find a connection to the United States, things like that. And you can also bring them here too. I mean, if the infringement happened here, but they're located somewhere else, it's harder to do. But anyway, yeah, it's possible. But yeah, I am talking mainly about U.S. copyright law. Yeah, I should have mentioned that earlier, actually. But yep, good question.
I should have. But can also and I apologize if we already touched on this, but another question is, so can you copyright a body of work, or does it have to all be individually registered? I know a lot of portrait photographers do series and things or other fine art, and photographers have bodies of work in series. Can you register the series, or it has to be every individual?
Yep, you can do groups of work, groups of photos all at once under one registration. I mentioned that there are limits on how many photos you can do at once, but you can do groups of work. One thing is important to note that you may want, there may be, I mean, this is getting into the weeds, but just there may be copyrighted work within the image. So if I took a photo of a painting or something like that I did not paint, and that was the main part of this image, I may have to disclaim that part of the photo. Like I'm not claiming copyright on this sculpture that's in this, but that is something that generally is addressed during this registration process. The examiner, the copyright person reviewing this registration may ask this question of you if they see something in there and they say, hey, you know, there's this other body of work in this image. So yeah, that's why it's good, you know, if questions, always talk to an attorney or try to do a search or something. And you know, to keep that in mind. I'm not saying you need to disclaim everything in a photo, but it could be a question that comes up.
Well, it came up a lot for us when we used to run, like when we had the print magazine, and if we ran an image, a lot of wedding photographers seem to love to put their couples in front of like a big wall that has a mural on it. But the mural is actually like the copyright of another artist, right? It's like that is like the work of somebody else. And so I could see like that could be sort of what you're talking about to a degree.
Yeah, in New York, there was a big case of a muralist. I don't know. I know this. I think I know the singer, but I don't want to say because if it's wrong, I just don't want to say the wrong facts. But anyways, there was an album cover. It was a background of an album cover. It was in front of a very famous mural by a really well-known artist. An artist sued for copyright infringements. So it can, and those things can happen where you are taking. It is important. It's something that a lot of people. I mean, it's hard to think about that. Sometimes you just don't think about it. It's in the public or whatever, but sometimes murals are if it's like a main component of this, that's where fair use comes in. Are you allowed to take these photos? And depending on how you're using it, all those questions are going to be fought over in court, but it's just something to kind of keep in mind too, and also how are you using the image? You can take pictures of people if those photos are just going to be on their refrigerator or something, but if it's going to be out and you're going to use it for advertising or whatever, then you know, that's.
What if you're winning an award with it, right? In a photo competition, and it's like 90% of the image is the mural behind the couple.
Right.
I mean, these things come up all the time.
Yeah, they do. And there's a lot of litigation about it. It's very fact specific. But yeah, those are things to be mindful of when you're doing, you know, when you're using someone else's copyrighted work. Just like imagine if I were a photographer, I had this amazing landscape photo and another photographer took a photo of, you know, a subject with that as a background. Maybe that as a photographer, I might feel like, hey, you know, you're using my photo and, you know, really without permission as this backdrop. So there could be issues. So you can kind of think of it like that too. Right. Make it more personal, I guess.
Okay. And again, I apologize. I'm bouncing around a little bit as I see things that pertain to things we might have just spoken about. So somebody asked, if you have a photograph or photographs from the 90s, can you still have them copyrighted? So there's no like, this might be the wrong phrasing. There's no like statute of limitations on when you copyright something that's been in existence for a long time.
No, I mean, you can copyright, copyright does, it's the registration itself, it's copyright lasts the life of the author. So the person's life plus 70 years. So whoever took it, the photographer, they die 70 years later. That's how long copyright lasts. Sometimes they transfer the copyright though to someone else and that extends it because that person's still alive or whatever. So certain stuff like that. And then once that happens, then it goes into this space called public domain, which is basically kind of a free for all. Anybody can take images. That's one way to get it. So yeah, so there's that. So, but yeah, you can sit on your rights though, and then register them later. That's fine too. You're not gonna run out of, unless, you know, you pass away and 70 years go by. So.
Okay, let's see. There's a lot of questions. So I'm going to see how much I can jam into 10 minutes. And I thank everybody for their questions because they're really great ones. Ian asks, many social media companies remove metadata that includes copyright. Wouldn't that be a violation of the Millennium Copyright Act?
Yeah, removing metadata, it can be removing copyright data. So that is part of the copyright. Removing data of ownership may be a violation of the Digital Millennium Copyright Act. Yep. It depends on why they're removing it. You just maybe that's one thing too. You always want to, before people jump the gun and are thinking, oh, somebody did something wrong. It's always good to really look at everything, and perhaps they had a right to do it. Maybe you licensed the image and forgot about it, or maybe you licensed the image and granted someone a sub-license or whatever. It's really important to kind of look at stuff, because a lot of times I do get a lot of cases, and then I do all the due diligence and I find out, okay, well, actually, they had the right to use this stuff. So it's important, just before people kind of fire off emails or send letters or whatever, to do that, because real quickly, when you do accuse someone of doing something, they do have the right to take you to court as well. Not for defamation, but basically for a declaratory judgment, is basically to say, hey, this person's threatening me of a suit. I'm just going to go to court and let the court decide right now whether or not I actually did something wrong. So you may end up in court when you don't want to be, when you accuse someone of violating the law. So it's important to figure out, to make sure you're right before you do anything.
I mean, sometimes people don't know that they've been infringed for a very long time. It's unfortunate that doesn't even come to light right away.
Yeah.
And I don't really know the answer to how you find that out sooner, unless somebody tells you. Often somebody will tip off a friend or something. But somebody else asked, this makes me laugh, but it's something I was thinking about too. Do you think the Copyright Office will ever make the process easier to use? Because that's what's holding David back from including copywriting his photographs. I think the process is so mind-boggling to a degree.
Yeah, I hope so. I see a lot of different registrations. I mean, Trademark Office is a separate intellectual property right, and their website is great. So yeah, Copyright Office has a lot of ways to go to get this all worked out. But yeah, it's a weird application. The interface, I mean, just stylistically, it's really kind of difficult to navigate the application itself. The terms are kind of hard, whether it's published or unpublished, and whether things were photographed in the same year. But like I said to you, once you do it a couple of times, it is worth going through the application and figuring out. And even though it is like it feels like a very old, outdated website, they do have these circulars. They do have that's what they call them, this information about the Copyright Office offers really good, actually, they are a really good resource for information on copyright. So if you don't know what published, non-published means, and you don't know, whether you need to attach the photograph to it or whatever, they have a very good, they're very good at having information available to people to answer those questions.
Getting back a little bit to before, when you were talking about the McCloskey case, the gun-toting couple, as I like to call them. Probably shouldn't say that too often, but like in terms of somebody asked, like on another person's property, and you get into trespassing, what about when the paparazzi are taking photos, right? Are they, that's a whole other.
Yeah.
But why is that different?
So it's not actually. That is a problem too. How they use the images and things like that. I mean, whether something's an invasion of privacy, it's state law, and New York actually has very limited privacy law, limitations. And there's a case about a person taking a photo from their apartment into the apartment across the street, and what they saw, and all this stuff. And the photos became really, really famous. It's a big case. So whether that was an invasion of someone's privacy, and that's kind of, that does happen. Celebrities do sue for invasion of privacy all the time. to try to get somebody to stop using photos because if they were taken in a way. But kind of going back, and it's kind of a hard thing to wrap your head around, but there is a difference between kind of owning something and then having the right to do something with it. So even though the photographer may own the copyrights to it, and that means they can prevent other people from using the image, they may not be able to use the image themselves for certain purposes. So that's kind of the issue, like with the McCloskey thing, is that did the photographer have the right to do it if they were trespassing on the lawn? So I think obviously he has the right. A way to say it is that he has a right. He owns the picture, but maybe he can't use those photos for other commercial.
Right. I mean, I think that Greenblatt, who was the photographer, I think, if I'm remembering correctly, was like on a public walkway in front of a private house, right, or property.
Right. And the defense to that too is that if it's newsworthy too, and where you're standing, and whether it's newsworthy, whether it's going to be a central question whether really it was an invasion of privacy. So that's going to be battled out. But I personally don't think it was. What you see from the street, from a public place into a private place, is generally fair to use. You can photograph away. That's a privacy question. Yeah.
But when in doubt, ask your attorney is the bottom line, right?
Yeah.
Somebody else had a question. A major sponsor is requesting permission to use photos and screen captures from our virtual film festival. What information should be included in our permissions contract concerning usage and protection of third-party copyrighted works, i.e. photos, film, musical performances?
Yeah, there's a lot of in there, because you're gonna have to, it goes back to who owns the copyright. So if the film was made by this one person, and they own the rights to everything, that's good. If not, if it was a collaboration, they might, and there's joint works of authorship and partners and people, they might need to, the person who's taking these stills may need to get permission from everybody. So it really is, a lot of the onus is on the person wanting the stills to clear it, because they could be they're going to be the ones that they could be the ones that are ultimately liable for infringement if someone else says, hey, I didn't, they may have given you permission, but I didn't, and you were using a piece of the film that was something I did or something like that. So you need to clear rights with everybody in order to do that. So you need to find out first what's in there, who owns the copyright, and get permission from everybody.
So another person asked, if they take photos at a public event like the Renaissance Fair, do some or all of the characters they take pictures of have any rights to profits that the photographer might get when he sells the images? And
so
that might,
you have the right to sell your images. It's a question of advertising, how you use it, whether you're using the likeness. I mean, selling an image is different. You're allowed to take, if you are allowed to take photos in that space. So if this is a private space and they say no photography, that could be a problem. If you're taking pictures of that, so you're be in violation of someone's rights that way, their own likeness. But yeah, I mean, but if you're able to take photos and you see it, you can sell your work. It's when it's a question of whether you're really using this work to promote yourself, and it's very state specific, because every state's going to be different about using someone's right of publicity for your own commercial gain. So
okay, well, sorry to interject, but we might be bopped off in a minute, so I have to wrap it up. But I thank you so much. I mean, there's so many questions I would have loved to have gotten to, which means we should do this again. But I thank you so much for your time, Aaron. I thank everybody for joining and for asking all the questions. Tune in to rangefinderonline.com to find out what our next webinar will be, and to see all the topics we're talking about this week online with copyright, things that Aaron has written for us. So there's more to come. And thank you so much, Aaron.
Yeah, thank you, Jacqueline. And thanks, everyone. Great questions. And yeah, thanks for the opportunity to do this. So.
Have a great day, everybody.
You too.